Good morning, everyone. Thanks for joining. I think this is probably one of the most popular events we've had in a little while in terms of how many of you have asked to join and responded. So hopefully between us, we think we've maybe hit the nail on the head in terms of what topics are of interest and pertinent to you guys at the moment. So I'm sure you'll find it useful and very engaging as always with both Fiona and Hermes. So without further ado, I will pass you over to Hermes.
Thank you, Verinda. Good morning, everybody. Good morning. Thanks for joining us today. So as Tom mentioned, there is the facility to be able to speak. I know he said if you prefer to speak, and probably 90% of us prefer not to speak, but it's quite nice to. And what we are aiming to do today is work through case studies that really pull through themes that we deal with as HR professionals day in, day out, as business owners and whatnot. That really kind of hit the nail on the head. And we would really like the session to be informal, interactive, not just us speaking at you. So feel free, please, to raise your hand and speak, and we can have a dialogue. But if not, we do have the chat function as well. So we will be monitoring that, having a look at your comments and queries. So please feel free to shout out at any point, because as I say, we'll get more out of it if we're all sort of contributing to it. So let's kick off with the first case study. Right, okay, so we're going to take you through a journey, a scenario and a week that some employees have at a recruitment agency business. So a new male employee joins Ready Recruit, which is a recruitment agency, as a recruitment consultant and does not disclose any disabilities. So he is working full-time. Now, just a few weeks after joining, the recruitment consultant reveals that he has a disability, ADHD, which is affecting his ability to hit his performance targets. Now, ADHD, so that's attention deficit hyperactivity disorder, neurodevelopment disorder, and I just got the definition here, so just so that we're all on the same page. It's a neurodevelopmental disorder characterized by persistent patterns of inattention, hyperactivity, and impulsivity that interfere with daily functioning. Okay. So the question here is it fair to penalise the recruitment consultant for not revealing that he has a disability earlier, ADHD? What do we think? Just give you a few moments. Feel free to, as I say, raise a hand or write in the chat.
Or I suppose another thing is, you may have had this situation. So looking at the chat, we've got quite a few people saying, no, it's unfair. No, he doesn't have to tell us. No, he might not have felt comfortable or safe to declare at the start of employment, which is, completely understandable, isn't it? No, but one thing I would say is you don't necessarily, you may get some employers who might go, well, hang on a minute, no, because I feel that, I've been hoodwinked here and I didn't know the full set of facts. But no, I think the consensus is, Hermes, from this, no, we didn't have to.
Yeah. And I think that's broadly right, isn't it? I guess, again, we've been deliberately woolly in the facts, haven't we, in terms of the actual scenario. I guess the first point to mention is normally this sort of information, well, when do we become aware of this information? Typically speaking, there tends to be a pre-employment questionnaire, a medical questionnaire that we ask for, don't we, as part of the recruitment process. So I guess it's, we don't know, was that kind of a condition of employment, wasn't it? If it wasn't, then actually, yeah, they don't have an obligation, employees, to disclose that sort of information, really. But if there was a pre-employment questionnaire, that might raise some questions in terms of, well, did they complete it honestly? Was there dishonesty involved? So you might get into those sorts of issues if you wanted to. Typically, as I say, as a lot of you have said, the idea is that you tend to approach the situation in a more sympathetic way, and actually the employee may not felt comfortable disclosing at a certain point. I guess where it becomes tricky is if it's a condition which affects their ability to do the role. So obviously some of these medical questions that we do ask that are conditional on employment, they're to ascertain, you know, if you're able to do the job. And that's where you might hit a problem. Obviously in this scenario, ADHD, recruitment consultant, it doesn't sound intrinsically linked. You know, we're normally thinking about things like, well, if it's a manual job, can they lift and climb and all the rest of it? So that's when you might be in a slightly different situation. You might actually think, well, okay, the fact that we didn't know this now means that this individual isn't able to do their role. In that scenario, it might be a case of, if the offer was conditional on satisfactory medical information, you might withdraw the offer, or if they're already employed and then you find out, it might have to be a termination based on the fact that they can't do the job and they've not disclosed that to you earlier. But typically speaking, in this sort of scenario, it sounds like you would crack ahead in terms of, you know, now that you've got that information, moving on to the next step. I can see some chat things popping up. So
yeah, I was just going to say, in the chat we've had, you know, if the person wanted to rely on adjustments at work, he should have disclosed it. And I mean, we can ask, can't we, if somebody requires adjustments for the purposes of interview, but if they haven't given us that information, then it would really be once we've selected that we would then be in a position to ask about health related or disability related issues
at the offer stage.
So that we can then make adjustments. The next comment is, often they say they don't complete it honestly as they feel they will be discriminated against during the recruitment process, and that may be the case. You know, that is the whole purpose, I suppose, is that this protection is there to make sure that everyone is on a level playing field. But it does, and I don't know how really, if somebody does raise that, it's a tricky one to navigate through, because you may well be sympathetic to that. And the other questions that are being raised are, you know, would the question itself raise the issue of disability discrimination? I mean, you can't ask those questions pre-employment unless it's for the purposes of finding out about reasonable adjustments for the interview. Once we've offered the job, or they're in a pool from which they will be selected for the role, we can, but that's for the purposes of, you know, making adjustments at that stage so that we'll put everybody on a level playing field. And I suppose if you did get the scenario where somebody can't do the job, can we do any reasonable adjustments? If we can't, then we would be saying, you know, justifying why that is the case based on that.
And that kind of lends nicely into the next question, which is, what steps should we now take, and was there a risk in us not knowing sooner? And I think that kind of feeds into some of the comments in terms of, well, yes, if we didn't know sooner, then it creates these risks in terms of, is there a health and safety issue we weren't aware of? Can that lead to personal injury issues? Are there any reasonable adjustments that needed to be made? I suppose just the thing to be mindful of is knowledge. So as an employer, you for certain types of claims, you're only liable if you actually had knowledge of the disability. Now, that's not kind of, doesn't apply across the board, but for reasonable adjustments, for direct discrimination arising from, you know, those kind of normal disability discrimination ones, typically you need to have some kind of knowledge, whether it's actual knowledge, so that they've told you, or what we call constructive knowledge, which is a situation where, you know, you can't just kind of turn a blind eye to something that's obviously a situation. So if you recognize from the behaviors of the employee, or there are certain clues, you know, a tribunal will kind of put that constructive knowledge on you to say, well, actually you should have known. So the knowledge is, I guess that's an arguable defense to say, well, actually they didn't tell me, there weren't any clues to indicate, and so we didn't know. But then there are some claims where knowledge isn't kind of needed, if you like. So for example, harassment, you know, anybody can be harassed without you necessarily having to know what their protected characteristics are, or, you know, if they've been offended by comments. Equally, indirect discrimination. So again, there isn't a knowledge requirement for certain types of claims. So it's just to bear in mind that whilst there is a slight defence there, overall, it's always best to try and obviously get the employee to be able to disclose these things so that we can act on them. And typically in these sorts of situations, the best thing to do is get an occupational health report, you know, so that you know where you stand, so you know how to support the employee. and what adjustments need to be put in place. So typically that's kind of, your risk assessments, your occupational health assessments are the best next steps to take. The recruitment consultant is not referred to occupational health, okay, against our advice, and is asked to get on with it. He's told that if he can't hit his performance targets, he will be managed on his performance. He's also told that he should call in sick if he does not feel well enough to complete the tasks assigned to him. Okay, so what are the risks with the approach taken? Yeah, I can see that some of the chats as well. Yeah.
Failure to make reasonable adjustments. Yeah.
Brilliant. Yeah, and that kind of feeds into the next one. What claims could the recruitment consultant bring? Yeah, so the key one is the reasonable adjustments, isn't it? Ultimately, there are a number of different kinds of disability discrimination related claims, but that's the risk, isn't it? That we are opening ourselves up to disability discrimination claims, because for all we know, firstly, the disability may cause the performance issues, which may then mean he can't perform and reach the targets. The comment about getting on with it, what do we think about that?
I think everyone has identified in the chat as, potentially discrimination, and again, a failure to accommodate. So I think everyone's on the same page in terms of failure to make reasonable adjustments and potential discrimination angle.
Brilliant. Perfect. Thank you. We can move on to the next slide.
Fabulous. So this is me now. So we've got a conflict arising because this is a nightmare week. So it's going to get worse. And we have the recruitment consultant doesn't want to risk rocking the boat, which we all see that, don't we? That people start at work and they, want to get on with things. They don't want to be the one to raise a complaint. So he gets his head down, but over a period of 12 months, he notices that his condition is getting progressively worse. And I think that would be a flag for me. We've got a long-standing male team leader in the team getting frustrated with the recruitment consultant's speed, and has been making inappropriate jokes about him to other colleagues in the office. The team leader has also shouted at the recruitment consultant and called him a waste of space in front of his colleagues, including the department manager, and nothing is done about that. So in terms of just going on to the next slide, we've got some questions here. And I suppose we've got to think about, how do these developments affect the risk in this matter? So I don't know if anyone's got any thoughts. It might be useful actually to flick back to the facts, because I appreciate it was a lot to digest. So Tom, if we could go back to the previous slide. But in terms of risks, what would people be concerned about here? I can see we've got risk of harassment claim related to disability, increased risk, potential harassment, exactly. Agree with all of that. For me, we've got the condition getting worse, which is of a concern. We've got inappropriate jokes in front of other colleagues. We've got being called a waste of space by the team leader. And again, are there any other facts that are of a concern to people in this scenario that I haven't mentioned? Exactly. Andrea has just noted deputy manager should have stepped in. I think remember that management have a responsibility in relation to disability, in relation to discrimination and harassment cases. As an employer, if we are faced with a claim of discrimination or harassment, we will want to rely on a reasonable steps defence, that we've taken all reasonable steps to prevent the issue occurring. That means that we have policies in place, we have training in place, that it's not a tick box exercise because we have to do it. We really invest in this, and that we take relevant action. So I wouldn't expect a team leader to be behaving in this way, given they are in a leader position, but certainly for the department manager, have they been a bystander to this? Have they done anything? Why haven't they called it out? So that would be a real concern for me in terms of, you know, what action has this department manager done in relation to this? I think the other questions we asked are in relation to the potential claims as well, which again, I think we've probably identified. We've got the condition worsening as well. That's a real concern. And again, another reason why as employers, you know, people do have health conditions, but by supporting them, we can hopefully, and putting reasonable adjustments in place, we can hopefully, you know, get them performing to a really good level. Here we can see somebody just being told, you know, that not being recognised, adjustments not being in place, and it's really now, one, affecting his performance, but two, making his condition worse, which is of concern.
Yeah, we had some comments, Fiona, right on that point in terms of shouldn't there be discussions with the consultant about his condition and his condition getting worse? So welfare meetings, discussions.
Exactly, that's spot on. And in terms of this department manager, I think, you know, really should have spoken to the individual, managing and resetting expectations in terms of this isn't appropriate, but looking at if these comments are being made, actually that's not the way to address them, and how do we address them? And let's have those conversations with the individual. You then know to put the relevant support in place. The team leader's behaviour needs to be addressed because it's a wider issue. Other colleagues are in the office. This is not conduct that is acceptable. So lots of things coming into play.
Yeah, and we've also had the comment of PI claims, health and safety.
Yeah.
So yeah, absolutely.
Yeah, exactly. That's the other angle that we've got to think about. So discrimination, harassment, PI, constructive dismissal. This guy could just get completely fed up and okay, it's, you know, we're over a period of 12 months. You know, we're not yet at a stage where he could bring a claim for unfair dismissal, but if it continues, it may well get to that stage. If we could move on to not to the next slide, but the slide after.
Yeah, so it's back with me. Thank you, Fiona.
Thank you, Hermes.
Right, so the recruitment consultant goes off sick as he can no longer cope. Well, unsurprisingly, the recruitment consultant was required to telephone his team leader on the first day of sickness to report his absence under the company's sickness absence policy. He doesn't do this and says his ADHD makes it difficult for him to have telephone conversations as it causes him stress and anxiety. The team leader insists that the recruitment consultant must call in and warns him that disciplinary action could be taken against him for breaching the company's sickness absence reporting procedure. Are there any risks with this approach? So in terms of the team leader insisting that actually we need a telephone call, that's what the policy says, and that's what we need to do. What do we think? Yeah, I can see failure to make reasonable adjustments. Yeah. Why aren't they allowing? Yeah, exactly. And that's spot on in terms of the case I wanted to talk about. So there was a very recent Employment Appeal Tribunal case against Fujitsu, and basically the employee there was, I'll tell you a bit about it, it's quite interesting, and actually I think we're going to see more and more of these sorts of neurodiversity related claims. There's an employee who had ADHD, software developer. He raised grievances against Fujitsu for failure to make reasonable adjustments, and it was basically bang on this scenario in terms of him not wanting to telephone when he was sick because it caused stress and anxiety, and just other ways of communication. So it was kind of this real lack of receptiveness to his way of being, and I think there sometimes can be a reluctance by employers in terms of not falling outside of policy, so being quite rigid in terms of, well, the sickness absence policy says you need to call in, so you need to call in, and sticking to policy. But actually it's a real eye-opener, this case, because it just shows that actually a lot more is expected if you have an employee that has a disability. So it was found that yes, the requirement to telephone in was a failure to make reasonable adjustments, and as some people have rightly commented, the tribunal noted that actually you could have allowed him to send a text or an email, or allowed a friend or a relative to call in instead. There are some other failures to make reasonable adjustments, but I do want to highlight them just because I think, again, that these are things that it might not readily come to us sometimes when we're kind of busily operating at work, but if under the microscope, you know, that they could cause liability. So the other issue was requiring primarily verbal communication. So Fujitsu had this policy where, although they had like a platform online to send messages, they wanted verbal communication, and obviously that was an issue for Mr. Duncan. And actually the tribunal found in that case that it would have been a reasonable adjustment for his team lead to mainly communicate with him in writing. So again, it's just tailoring solutions to the individual. The other thing that they found was a failure to make reasonable adjustments was there were uncoordinated procedures regarding provision of written information or meetings, agendas and goals. So with ADHD, my understanding is that being provided with information beforehand, being caught off, they need more time to digest and process information. So actually the haphazard way that the business was operating put him at a substantial disadvantage. So, you know, there wasn't much pre-planning of meetings, he wasn't given things in advance. So they found, actually the tribunal found, he was disadvantaged by that lack of pre-planning in meetings. That caused him stress. It made it difficult for him to participate, not providing him with an agenda in advance so that he could meet his expectations. You know, it said the agenda it didn't need to be very detailed, but it was just, and it didn't mean that you had to stick to the agenda topics, but it was just saying something that would set his expectations, that would give him some food for thought, would have been helpful and reasonable. So I thought this was a really interesting case because it's recent. It's something that I think we will come up against time and time again, and sometimes it's that extra attention to detail, isn't it, and effort that we might kind of miss in our day-to-day operations that actually in this case caused these claims to be successful. The other point I wanted to highlight about this case is actually Mr. Duncan was also dismissed, and he did bring a discrimination claim for his dismissal. Now the reason for his dismissal was because he said all of these actions, or failure to act by the employer, made him very frustrated, and actually he ended up kind of lashing out. And the way he lashed out was on one of these platform messages. He actually wrote a very inappropriate comment. He said, "I'm going to effing string all of my all of my colleagues up by their ankles, every last one of them." And actually, in relation to that, even though he said, the reason I had my outburst was because I was frustrated because of the way that they were, you know, the inaction in dealing with my disability related issues, the tribunal said, well, hang on a minute, there is a line to be drawn, and Fujitsu was in their rights to go through a fair process with you and dismiss you for gross misconduct, because actually no employee is allowed to behave that way. I mean, even considering the standard of disability and that there might have been a link there, they found that actually it was proportionate for them to dismiss him in that situation because of the nature of what he said and the gravity of what he had done. So again, it kind of just feeds into Jane's point earlier in terms of, yes, he won on the reasonable adjustment side, but there is a line, and if that's crossed, then you can be within your rights to take action. Okay, next slide, please.
I think the only other additional points that I would say as well is just there is really good information out there. I think ACAS have got, because I think from our interactions with managers, managing mental health within the workplace, neurodiversity is a real, we see a lot more queries coming out of these. ACAS have got some really good guidance in terms of how to manage that area, thinking about some of the reasonable adjustments. There is also, and I forget which forum it is, and if I can quickly find it, I will put it in the chat before, but there are forums out there as well which have, you know, great, there's a wealth of information so that you can really educate managers about what kind of reasonable adjustments, and you can ask the person as well, you know, how can we support you, but it's that asking, but also thinking and tapping into the tools that are available to us, because it may not be those straightforward, you know, shorter day, different tasks. It might be that somebody wants to work within a quieter space of the office. It could be a number of things. So just thinking and kind of getting some education on that, I think, is really worthwhile. And the other thing I would say is, just in terms of as employers and reasonable adjustments, remember that tribunals will look at what is reasonable. It also depends upon the context and the employer. And for a large employer with a big brand name, or a client that's everybody knows, a brand that everybody knows, or I'm thinking about some large public sector organisations as well. If you're a large employer, the expectations are going to be higher than a business that has one employee, of course. So just think about that as well, because sometimes I do see employers saying, I've got so many people with this request, I can't accommodate, how am I meant to service? A tribunal will say, well, come on, you're a big employer, you need to be making these accommodations. So that's just another flag from me.
And also, actually, you reminded me, Fiona, that in terms of managers, that is another thing in terms of awareness. So sometimes what happens is, HR will know there's an issue, or some managers might, but where it's a busy operation where the managers change and there's shift managers, sometimes not all of the managers are aware of the situation, and that is a weak link, because I've had that where some clients have said, oh, well, that manager didn't know that the employee had ADHD, but that's not, vicarious liability works in a way where once the employer has the knowledge, everybody is assumed to have that knowledge. So that's not a justification to say that manager didn't know. So it's very important to just have that, that link of communication between everybody that manages the individual, to make sure that you don't kind of lose or drop the ball anywhere.
Yeah, and that's a good point, because I've seen that with pregnant colleagues as well, where perhaps information hasn't been passed down, and then it can cause a whole host of issues. Right, so now we're now looking at the team leader. The team leader is putting in a flexible working request. This is a month later. The team leader has split up from his wife. He submits a formal flexible working request due to childcare reasons. And I'm just going to jump to the first question is, should the team leader's flexible working request have been approved? Now, I completely appreciate we've been very sketchy here and not given you the full details, but I suppose, childcare reasons, probably not if you've come into different personal circumstances. I don't know what did people have any thoughts about it? This is a male making the flexible working request for childcare reasons. Any initial thoughts on that? If they can accommodate, they should. I guess that depends on why it was refused, unless there's an appropriate business reason. Yeah. So you're right. It all depends on the facts. I suppose one flag is, in this scenario, it is a male making the request on the grounds of, childcare reasons. Remember, with your flexible working requests, what we need to be thinking about is, of course, following the procedure, because there can be claims under the flexible working regs for up to 8 weeks pay. If someone isn't happy with the outcome, they could resign, I suppose. But we're also always looking for a discrimination angle, particularly if it's for childcare reasons or perhaps caring responsibilities. Now, we all know that if it is a female making the request for childcare reasons, the potential is, if we refuse, that there could be an indirect discrimination claim on the basis that statistically majority of women are responsible for childcare responsibilities. So you may on the face of it think, well, no, I think we're okay here because it's a man who's requesting this, not a female. However, it was just a flag. There was a change last year. We've got new Section 19A of the Equality Act, which essentially treats men the same. So it's to highlight remember, if you are getting your flexible working request, they're for childcare reasons, they are from a male, then they too can bring a discrimination claim. So it's a watch out. And I suppose flexible working, you know, we saw substantial changes to flexible working last year. It's a day one right now. They can make 2 requests per year. And also the government is going further with that in terms of wanting to make it a default position. So I think the flag is, remember those 8 statutory grounds which we have to rely on, reference those. It must be reasonable as well in terms of why we're saying we can't accommodate it. And I think my top tip in relation to flexible working is, if you do have a concern with it, I think often employees are willing to look at a compromise because they want it to work for them too. So look at compromises, but also tribunals love trials. So if you're saying, I don't think this is going to work, why not do a trial? Because if it doesn't work, your trial's going to show it doesn't, and you're all on the same page. Or do a compromise or a trial of a compromise. It's just to highlight it's not simply a yes or no. So in this instance, you know, it has been outright rejected. There is a risk there. And I think the employer needs to have a wider scope here in terms of looking at the different possibilities. I don't know if there's anything in the chat, Hermes, that's worth
Yeah, it's all
adding.
bang on. Everybody has got all the right answers. So consider alternatives, trial periods. So yeah.
Oh, good. We're all on the same page. So it then develops, the team leader has had their request rejected. In an act of rage, he takes it out on the recruitment consultant, who's now returned to work. He shouts at the recruitment consultant, calls him an effing useless idiot following an argument about the recruitment consultant not undertaking certain tasks. The team leader storms out of work before the end of the day and is not contactable. What steps should now be taken?
Any thoughts?
What do we think of the team leader in this scenario?
Yeah, it's tricky, isn't
Yeah,
it?
I mean, that is a real good flag that I think should be considered. Clearly, this team leader is under, I don't think he's probably behaved very well to the recruitment consultant in the past. We've got a bit of a flag here that clearly there are difficult personal circumstances. It doesn't condone how he's behaved, but I think it is a contributing factor. We know from, well, you may not remember from an earlier slide, it said he was long-standing. You know, he sounds like he's been with the business for a reasonable period of time. He's going through a rough patch. Yes, it doesn't condone behaviour like this, but we do need to provide some support there as well. And, you know, some of you are flagging, you know, is this managing this through a formal disciplinary? Potentially. You would look to your rules of conduct, but behaving like that, swearing at someone in that way, in the circumstances, is not reasonable behaviour. And whilst there may be mitigation, of course, we would look at that. So I certainly think that, you know, this is a team leader as well. Not only have they behaved in that way, they've then gone AWOL for the rest of the day without being contactable. So they've not, there's a catalogue of things there which I think would potentially merit a disciplinary in relation to misconduct. I don't know if anyone would think about suspension. You know, if we're looking at the more serious end of conduct issues, remember we're looking at suspension as, you know, we'd explore other alternatives before suspension where possible, because we don't want it to be seen as an act of you know, too heavy-handed, because it then could lead to further claims in relation to constructive dismissal. But yeah, exploring whether anybody thinks suspension might be an option. Remember, it's where there's, you know, risk to property or person. It might hamper the investigation. or there's a real breakdown in trust and confidence. Don't know if I would necessarily be veering. I certainly can imagine some employers might suspend in these circumstances, but I don't know if anybody wants to. We've got some comments here about this. Are there alternatives to suspension? Temporary redeployment whilst investigation? Yeah. I think you'd have to assess that, wouldn't you? And look at all those factors, but suspension might be in the mix as well. Okay, should we move on to the next slide?
So
I think back with you, Hermes.
yeah, the team leader is suspended on the next day, and he submits a formal grievance alleging that the company has discriminated against him by refusing his flexible working request. And he also raises a new complaint that the recruitment consultant has been sexually harassing him at work when no one is around. All right, spanner in the works here. Okay, so do we need to hear the grievance before a disciplinary hearing takes place? So obviously we've got a team leader that's suspended pending disciplinary, but then he's also raised a grievance. And I'm sure 9 out of 10 of us have come across that, where you're going through a disciplinary and then lo and behold, you also have a grievance. So busy chats. What are we? We've got lots of yeses there, haven't we? Yeah, grievance. Yeah, typically I think that is the safest course of action, particularly since we have 2 grievances here, and there's some overlap with the disciplinary situation, but then not as well. So you've got this flexible working request grievance, which has nothing to do with the recruitment consultant, but then you've also got this recruitment consultant sexually harassing him issue, which may link in with the disciplinary. It might be mitigation, it might be the reason, you know, so you've got 2 things going on. So the safest course of action would probably be to do the grievance first, know where the land lies, and then proceed. But there are other options you can take. It's not like a right or wrong necessarily. I mean, the ACAS code of practice does allow for processes to run concurrently if they are linked. So for example, the sexually harassing, that is potentially, if it is mitigation, it could be linked to the disciplinary, in which case the manager considering the disciplinary could consider that at the same time concurrently and come to an outcome on both of those issues. But then you've still got the flexible working request issue that would need to be considered, which could run separately along at the same time. So there are ways and means. So ultimately really depends on how many managers you have in the business that can hear these separate things, you know, how big you are, the delay, how long. So there are options to take. I think the safest probably option is to do the grievance first and then move on to the disciplinary. But I can see that, yeah, you can, I can see some comments saying you can do it either way as well. So there are options, certainly. How would you handle the situation with a recruitment consultant? So now we have this allegation of sexual harassment. We're used to the recruitment consultant being the victim in this scenario. Now he's turned into the aggressor. So what do we do?
And quite that's really sensitive to handle, isn't it? It's a really difficult one to manage. What does everyone think?
Red flag, isn't it?
Certainly. I suppose.
Would we suspend? Would we have a conversation first?
Yeah, I mean, somebody's raised, is it a vexatious grievance? Because we've probably all seen as well things raised in response to a disciplinary. You would question if there had, and if this has happened, how long has it been happening and why is it being raised now? But then it might be that perhaps they didn't feel able to come forward, and actually now this has been like, no, I've got to say something now. This is, but we've got initial fact find, they could be sexually harassing others. We do have a duty of care to others. Could you remove him from the business temporarily whilst pending investigation as a suspension? Yeah. Get the details first. It would be difficult, but look to consider the validity of the claims and any previous disclosure. Decide if you suspend or redeploy. Get someone independent and outside the organisation to look into the sexual harassment. Take the complaint at face value. We would look to avoid to suspend and move them to an area away from the complainant. Try to understand the degree of sexual harassment as part of the initial fact find. really good responses.
Yeah, they're all really good and they're all right, aren't they? So
Yeah.
it's balancing the two, isn't it? So you've got the suspension discipline on one hand, then you've got this individual. So they're both victims and aggressors at the same time in different ways. And actually, we've got to be mindful of consistency of treatment as well. So that's something to bear in mind, that you've suspended one for one thing. Is it appropriate, say in this scenario, is it appropriate to then suspend this for the other thing potentially? But yeah, very much so. It'll be a case of probably doing an initial investigation with the recruitment consultant to understand his side of the story, and maybe trying to nail down, bottom out the details, you know, in terms of the vexatious part. You know, do we have we get a gut feel with these things sometimes, or the evidence does suggest a certain way. You know, if you look at CCTV, you speak to a few people, you might get a sense of it, but then again, you might not. So it's very difficult to ascertain really at an early stage whether there's merit in something like this or not, but you might be able to. So it's worth always having that initial conversation. But typically speaking, for in the interest of transparency and fairness, I'd say treat them both consistently. So if one's suspended, the other should be, and they should both be given the same benefit of the doubt in relation to the claims that they've made. Particularly with sexual harassment, there is another standard, isn't there? We know last year, October 2024, there's a new duty introduced on employers to take reasonable steps to prevent sexual harassment. Now, we know there was already a general duty to take reasonable steps to prevent discrimination, but we've got this specific one in relation to harassment now. And there sort of the law goes beyond just saying, well, you've got this duty to prevent sexual harassment. It says, well, you'll be punished for it if you don't. We'll uplift any tribunal compensation by 25% if an employee has been discriminated against for sexual harassment and you failed in your duty. So it's very important that we do look at that. And I don't know if businesses have paid particular attention to sexual harassment since then, but the Equality and Human Rights Commission has produced a guidance, an 8-step guidance note, which I would recommend. If you just type in Google EHRC 8-step guide, it will come up. But it's really good because I think it's, without taking the steps in the guidance, you as an employer will be very hard pressed as businesses to defend and show that you've taken on this duty and you've taken reasonable steps to prevent sexual harassment. So it's very important that we are mindful of the things that we should do before it gets to the stage of sexual harassment occurring. So preventative measures are key. What does that mean? Anti-harassment, sexual harassment policies. So some employers I know now have a specific sexual harassment policy. Others will join in with their kind of generic harassment policy. They're both fine, but as long as the sexual harassment statements say all the right things that it should do. So, sexual harassment's not tolerated, it's unlawful, disciplinary action will be taken, potentially if there is harassment or victimization, clear examples of what sexual harassment is and isn't. Third-party harassment, that's also this duty extends to third-party harassment as well, preventing that. So if you do work in an environment where you have customers coming in and out, bearing that in mind, that actually that's something we need to be mindful of, and really laying it out clearly what the steps are. If somebody is being sexually harassed or they think they are, what steps they can take to report it, what we as a business will do to prevent it. These are all very important things that should be in a policy. The guidance goes on to talk about other things that you need to do, engage your staff, make sure you talk to them in surveys, exit interviews. It's not good enough to claim ignorance. It's not good enough to say I didn't know anymore. So it's very much about being proactive, and managers, I think we've seen in these examples that managers have a very key role, and I've said this time and time again, they are the link, I think, that saves the business, because they're the watching ear on the ground. They can monitor employees, they hear things, and it's for them really to nip things in the bud or to report things back, because at the HR level sometimes we might not have that visibility all the time. So it's really making sure that we are informed, that we undertake risk assessments. Have we had this issue before with this manager? Are there certain teams where things can go a bit awry, or, you know, are there power dynamics in certain teams that might lend itself to sexual harassment issues? So it's really that inward due diligence that's needed. Making sure you have reporting mechanisms, training. I mean, I can't emphasize this. I think out of all the steps, training is the most important one. Making sure that you have effective training in place. It's not enough to have a policy. It's not enough to sort of do a one-time kind of training session with employees. It's very important that we ensure that actually we have this regular, proactive, interactive dynamic with our staff members, so that, you know, there's no excuse for employees behaving in a certain way, so that we can say, actually, they've gone off on their own and done this. We've done all we can to prevent it. And there was a case years ago now where, yeah, 18 months was between training was held to be too long, and it said that training was stale. So that it's very, very important that we bear that in mind. So in terms of that, I think it's the sexual harassment, it's very much going through the stages of investigation, whereby it's, again, the usual kind of fact-find situation, looking at evidence, physical, documentary, witness, and pulling it all together. But I am conscious of time, so I'll hand over to Fiona.
And we're going to go on to the last slide, which is the end of our case study. And we are now at the team leaders disciplinary. Now, this is all about postponements, because we all know that we often see requests to postpone. This individual requested to postpone his original disciplinary. The suspended team leader has now arrived for his rescheduled hearing. He's brought an employment lawyer with him. So should we allow the employment lawyer to attend as his companion? I don't know if anybody's had this scenario, but what do people think? We've got a no, only an employee rep or trade union. Yeah, completely agree with that. Remember, the statutory right is to a trade union rep or workplace companion. So don't need to allow that. I have seen a variety of approaches from employers. You know, some will take the view, as long as I kind of keep the remit of that person's role, then it's fine. But certainly you don't have to agree to it. And I suppose, you know, remember the role of the companion in the meeting. It is they're not there to answer questions on their behalf, unless we're doing that for the purposes of reasonable adjustments. So if you did have concerns about that, well, you know, and you did allow it, just keep those parameters, because ultimately, if they did step out of the remit of their role, you would tell them, and if it continues, you would pull an end to the meeting. If we're not allowing it, what do we say to the team leader about it? He's arrived, he's there with his employment lawyer. What would you be saying to the individual? So I've got reasonable adjustment, not allowed as a matter of policy. If you were, so we're going to say not allowed as a matter of policy. I suppose the next, yeah, all good points in terms of what people are saying. I suppose the issue is, do we then proceed or do we re-adjourn? And I think I would say to the team leader, look, we can go ahead today without a representative if you are happy to, but they've got to be happy to. If not, we will reschedule, and they'll need to get a companion of their choice that fits within the parameters that we've set. Okay, well, look, it is 11:57, so I'm very conscious of time. I hope everyone has enjoyed today. We wanted to do it as a case study chat. Obviously, it means that you are engaged throughout rather than listening to us speak all the time. It's been you've been so interactive on the chat, which is fab. As always, thank you for your attention. Do let us know of any topics or ways in which you'd like these sessions to be delivered. And I will hand over to Verinda for our close. Thanks, Verinda.
Thanks, Fiona. Thanks, Hermes. Thank you, everyone, for joining. I was riveted. Don't know about anybody else. But yes, just to reiterate what Fiona said, if there's any other questions or topics that you want us to cover in the future, realistically, we'll probably do something in September when everyone's had their summer holiday, hopefully. But anything you're particularly interested in, we may as well make it relevant to you guys. And please don't hesitate to reach out to me and let me know. And hope you have a wonderful rest of the day, everyone. Thank you.